Um, I'd like to start roughly where Mr. Thompson started in his argument, where he referred to our theory that a voter ID law can bear more heavily on one race than another, even if it doesn't disenfranchise voters, as, quote, a new twist. If it was a new twist, it must be news to the Court of Appeals, because that standard comes directly from their opinion at the preliminary injunction phase in this case. They ruled that it is, quote, the right to participate in elections on an equal basis that is substantial. Accordingly, whether plaintiffs could conceivably still participate in the elections by jumping through the allegedly discriminatory hoops of SB 824 is, in and of itself, not determinative. In other words, whether voters could overcome the barriers placed between them and the ballot and still cast a vote is not the determinative question. The constitutional injury here comes from being a member of a group that has been targeted by a law intended to make it harder for them to vote. All of our plaintiffs fall in that category. Here's the rub. If you take Mr. Thompson's logic to its endpoint, the legislature could declare openly on the floor of the General Assembly that it was designing an election law to disenfranchise African American voters. And if the very boldness of that tactic spurred African Americans to turn out at even higher rates than before, under their theory of the law, there would be no constitutional violation. That is a perverse interpretation of the constitutional guarantee of equal protection, and it is emphatically not the law. But in a way, it's not really surprising to hear this bizarre interpretation because, as I said in my opening, legislative defendants' theory of this case is really that some intentional discrimination is okay as long as SB 824 isn't quite as bad as the poll tax, quite as bad as the literacy test, or quite as bad as HB 589. That too is not the law. And we know that from looking at HB 589 itself. Mr. Thompson repeatedly pointed to March 2016 when he claimed that 99% of voters were able to vote as evidence that voter ID laws are not problematic and that this voter ID law would be no more problematic. But that election was conducted under HB 589. If the standard was success at disenfranchising voters, it's hard to understand how, by Mr. Thompson's own lights, the Fourth Circuit could have found HB 589 to be intentionally discriminatory. But it did. And the reason it did is because the evidence showed, just as it shows here, that the Republican majority recognized that it was politically expedient to preserve their power by targeting African American voters. Now, when it comes to that theory of entrenchment that we've talked about a great deal today, legislative defendants really want to have it both ways. On the one hand, they tell you there is nothing abnormal about a legislative process in which the Republican supermajority acted during the lame duck, while it still had the power to override the governor's veto, to enact its preferred form of voter ID before it lost some of that power. But on the other hand, they then ask you to turn around and believe that their preferred version of the voter ID law had nothing at all to do with trying to preserve Republican power. Those two arguments are completely incompatible. And the sequence of events shows clearly that Republicans leapt at the chance to put voter ID back on the agenda after the Covington case eliminated one tool for diluting the voting strength of African Americans, racial gerrymanders. The most rational inference to draw from that is that the legislature was engaging in precisely the same pattern we have seen repeated over and over and over again through history. Gains in African American voting strength followed in short order by facially neutral laws intended to beat back that progress. And Mr. Thompson also argued that SB 824 was race blind because the General Assembly didn't request new race data when it was putting together the list of IDs to include under the law. There's a difference between not requesting race data and not considering race. The Fourth Circuit didn't criticize the General Assembly just because it requested race data. It faulted the General Assembly for requesting that data and then using it to design a law that would disproportionately burden African American voters. The General Assembly had an opportunity here to request race data and use it for the opposite purposes, to craft a law that would be better than HB 589, that would be more inclusive. Instead, it willfully blinded itself to information that could have allowed the General Assembly to pass a more inclusive law. It is in that context that the failure to ask for race data, in light of what happened with HB 589, provides compelling circumstantial evidence of intent. Now, Mr. Thompson also argued, as we predicted he would, that votes by certain Democratic members of the General Assembly, or the fact that Democrats backed and succeeded with certain amendments, must negate any finding of discriminatory intent. But we told you in our opening that what was in the heart or the mind of any one particular legislator is not dispositive. That's still true. The question is whether the legislature had an incentive to entrench itself by targeting African American voters because they vote overwhelmingly and reliably for Democrats. And on those 2 points, there is really no dispute. As for the comments of individual legislators, Mr. Thompson offers you a false choice. He says that because Senator McKissick and Representative Harrison did not condemn SB 824 as stridently as they did HB 589, they must have believed it was a good bill. Their sworn testimony at trial obliterates that argument. The testimony from these legislators in this case is clear, crystal clear. Senators McKissick and Robinson and Representative Harrison did not support the bill, did not believe the process by which it was enacted was bipartisan, and they told this court in no uncertain terms that the rushed process of enacting SB 824 provided inadequate opportunity to debate the issues, much less shape the bill into something that they could have supported. But again, this really just reveals the heart of the legislative defendant's argument. So long as SB 824 is not quite as egregious as HB 589 was, it must be lawful. That's not the law. State defendant's argument is of a piece. Boiled down to its essence, the state would have you hold that SB 824 is not intentionally discriminatory because it may have some mitigating features that are more permissive than HB 589, and because election administrators will do their best to ensure that the law is enforced appropriately and even-handedly. But HB 589 did have some of these same features. It did have a reasonable impediment provision added to it, albeit later after it was initially passed. And the Fourth Circuit found in striking down HB 589 that that reasonable impediment provision did not completely eliminate the harm caused by the bill's initial passage. We know that because our plaintiffs testified that despite the sincere efforts of poll workers the last time a voter ID law was in place, which no one doubts, it did not stop voters from being given misinformation and from being disenfranchised. And importantly, the legislature knew that the reasonable impediment provision and the board's training efforts had not prevented the law from functioning as a fail-safe under HB 589. And yet it still moved forward with a law where voters who lack ID are consigned to voting a provisional ballot that may not count. A couple of additional points. Mr. Thompson told you that you should disregard the Court of Appeals opinion because the evidence at the preliminary injunction phase was not as well developed as it is now. Of course, we agree that after a 3-week trial, we have more evidence before us. But Joel Ford's affidavit was in the record at the preliminary injunction stage. The court did have the benefit of his testimony, and the court nevertheless found that a bill sponsored by Joel Ford, voted for by Joel Ford, was likely passed with an intentional discriminatory intent. And that's because of all the reasons that we've discussed today. It's because of the fundamental fact of racially polarized voting in North Carolina, and the fundamental fact that the Republican supermajority had and acted on an incentive to entrench itself just as it had in HB 589. Now, you also heard Mr. Thompson talk about fraud, and he pointed mostly to 2 pieces of evidence. He pointed to a chart from Professor Louloudis's report about non-citizen voting, and he pointed to a website from Senator McKissick that used the term rampant fraud. There's a couple of problems with each of these pieces of evidence, such as they are. The first problem is that the McKissick website came in for impeachment under this court's rulings. And so it's surprising to hear Mr. Thompson present it as evidence of actual fraud. The other problem is that once the burden shifts to the legislature to demonstrate that it would have passed this version of SB 824, notwithstanding an intent to discriminate against African American voters, it is the actual purposes, the actual considerations of the legislature that count, not a post hoc rationalization about citizen voting that the legislative defendants pulled from the expert report of one of plaintiff's witnesses, not statements from Senator McKissick's website. And as we explained in our opening, the question is whether this form of voter ID was necessary to achieve the purported policy interests of this legislature. The answer is no. They did not need to pass this form of restrictive voter ID in order to implement the constitutional amendment. They did not need to pass this restrictive form of voter ID in order to combat the purported instances of voter impersonation fraud. And they did not need to pass SB 824 to enhance voter confidence to the extent that a voter ID law can do that at all. And so at the end of the day, we come back to where I started, which is that this question is not about whether there's going to be any voter ID law in this state, but about whether this voter ID law can stay on the books given what the evidence shows. We believe, as we told you at the start of our opening, that the evidence overwhelmingly shows that this form of a voter ID law was passed to entrench the Republican supermajority by targeting African American voters, and that this form of voter ID law would not have been passed but for its discriminatory effect on African American voters. For those reasons, we would reiterate our request that this court heed the Court of Appeals opinion and conclude that SB 824 was enacted with an intentional discriminatory purpose to discriminate against African American voters, enjoin the law, send the legislature back to do the work that it should have done in the first instance, pass a voter ID law with bipartisan support after evaluating the issues, after collecting data, and create a law that North Carolinians can be confident in. The Constitution demands it. Thank you.
Thank you, Mr. Brockman. I want to commend the attorneys in this case in representing your respective parties. All of you have done a fantastic job presenting your cases in a very well-reasoned and easy to understand manner, and your respective clients should be proud of the job that you've done. I also commend the presentation that you've had, these folks working behind the scenes. I've heard Ashley's name probably more than any other, and I've never seen Ashley on the screen, but she's done a fantastic job as well. And likewise on the other side, I forget the person's name that was doing it for the legislative defendants, but it's been seamless. And so despite these circumstances of everything being online, it really went off well, I think. And I hope that each of you have felt like you've got your day in court, your 3 weeks in court. But all of you did just a fantastic job presenting your evidence and representing your respective clients. You all acted in a professional way, and I, for one, very much appreciate that. I also commend our court staff. Caitlin Beal, our courtroom clerk, has done an awesome job. Kelly Myers and all those in the TCA's office, and certainly our court reporter has done a fantastic job trying to keep up with everyone and hear everything. And so I commend her. But thank you very much. You haven't made our job easy, and that's the way it's supposed to be. But we will, I promise you, do our very best to render a judgment in accordance with the law and the facts as presented in this case. I also think that Judge Rozier and Judge Ofalu would like to make a few comments, so I'll turn it over to Judge Rozier.
Thank you, Judge Poovey. You've already acknowledged pretty much what I wanted to say, so I thank you for that. I don't have to be as detailed, but I would applaud the attorneys for your professionalism, and it's always good for a judge whenever you hear the attorneys say that they're going to work together on any type of issue, particularly whenever the challenges are as substantial as they are in this particular case. And so even last night, understanding that you were working on matters that's still somewhat comforting. But also, I feel you may see why I, as a Wake County judge, feel spoiled as someone who gets to work with Marin and who has Kelly Myers very much kind of as a lead for us in Wake County and being able to work with Caitlin Bill. The fellows that are able to work with the Superior Court judges. I'm spoiled and blessed for many reasons, but I count them amongst those reasons. And for Marion yesterday, I think you probably saw that was just stellar. That real-time underscore transcription was was awesome. And then Ashley, and I think as Judge Poobie was alluding to, Kate, I think it is Hardeman behind the scenes, the producers, so to speak, for the different parties. We thank you for that. But I think Judge Ofulu may concur in our thanks to Judge Poovey. We've been able to remain behind the scenes and not say that much. And as someone just by age and by just my likings, I'm familiar with Star Wars, and there are times where he's had played a Jedi mind trick, perhaps just by reading our minds and being able to go ahead and state what it would be that we would try to furthermore articulate much more than just a sustaining or object or overruling. So I thank him, and I look forward to sorting this out with my colleagues. But I did want to take the time to thank you all. It seems like I guess I got this started off at the first hearing for this matter, and so it's been a pleasure to see you all continue along. And again, I just thank you. Judge Ofulu is yours. You can go ahead, Judge Ofulu.
Thanks, Judge Rozier. I guess I'll just have to say that I echo everything that's just been said, but just to amplify it a little bit, sometimes people say, is it hard being a judge listening to really good lawyers? And no, that's the best part of the job, is listening to really good lawyers. The hard part is when you don't have good advocacy or you have people that are unrepresented. Those are the hard cases. Obviously, this is a very weighty matter, but the quality of your advocacy has matched the weight that of the matter that you bring before the court. I was also going to apologize to Judge Poovey privately, but now that Judge Rozier has apologized to him publicly, I want to apologize to him publicly too. You may have noticed that I'm a little more chatty than our other two judges. And Judge Poovey has done an incredible job of keeping everybody on task. And sometimes I'm frantically typing to him my opinion about things while he's trying to talk at the same time. So sometimes I have gone back at night and felt bad about the amount of times that I'm flicking away to him my thoughts on various matters. But most of the time, and I guess unanimously for purposes of the record, he has agreed with what I'm trying to type before I even can hit the send button. So I want to commend him for what he's done. I want to commend you guys not only for the professionalism that you've shown in this trial, but for the professionalism that you've shown throughout this case. We've been living with this case for a couple of years now, and the quality of the things that you've gotten to us and the timeliness that you've gotten to us has been pretty amazing. I'm also just really impressed with what you said, that you're in 2 weeks are going to have respective findings of fact and conclusions of law. My jaw nearly hit the floor when I heard that. I've had other cases where proposed findings of fact in much less complicated cases come in at a slower pace. So that's pretty amazing that you all can do that. And we look forward to reading both of them and deliberating upon what we're going to do. I've got to say something about the court personnel too. First of all, Marin is just a terrific court reporter, and it's just amazing that she's been able to get such an accurate real-time transcription to you all in such a timely manner. And we get them every night at about 5:30 when I'm even before I've gotten home. Marin has already sent an email. The amount of work that's been done by the judicial fellows and the court personnel behind the scene, I know you have an inkling of it, but it's been pretty amazing, and I want to thank them too. So I think I think that's about all I can say. And it's been a pleasure. I'm glad I'm going to do something different on Monday. I got to admit that. And when I didn't see anybody waiting in the lobby this morning, I was tempted to write hallelujah in the chat, but I'm so happy that I get to do something else on Monday. I got to give a special shout out to Mr. Cox for the no questions. That was great. We appreciate it. Thanks so much. I'm going to stop talking now.
Thank you, judges, for those comments. And is there anything else for the record before we adjourn sine die?
Your Honor, one thing for the legislative defendants, if it would be helpful to the court, we would be happy to and would like to move in for demonstrative purposes only the PowerPoint presentation from today, which is LX 272, and we would have no objection to the plaintiff's PowerPoint coming in as well.
Mr. Brockman or Ms. Riggs, would you all like to introduce your PowerPoint?
That would be fine with us, Your Honors. I did rearrange it a little bit this morning, and so I just want to check with Ashley to make sure that we get you the version that was actually used today.
Do you have any objection to the legislative defendant's PowerPoint coming in for demonstrative purposes?
No, Your Honor, not for demonstrative purposes.
Okay, what was that number again, Mr. Thompson?
LX 272, Your Honor.
Okay, LX 272 being the PowerPoint made during closing of legislative defendants is received.
Thank you.
And I'm sorry, it should be LXD or yeah, 272. There's a D in there to indicate it's a demonstrative. Sorry to interrupt.
Okay, it's all right. LXD 272 then.
Thank you.
Paul, I'm trying to get a number for you. Judge Poovey, I'm trying to get a number for you for our PowerPoint, and I'm
Sure, that's fine. That's fine.
looking at Ashley and Mr. Simons. PDX 7. Plaintiffs would move the admission of PDX 7 for demonstrative purposes.
All right. Plaintiff's PowerPoint used during closing labeled as PDX 7 is received in evidence for demonstrative purposes. All right. Is there anything else then?
No, Your Honors. Thank you all very much.
Okay.
Thank you so much, Your Honors.
Okay. We will stand adjourned, sine die. I hope that you all have a good weekend, and we'll be in touch soon.
Thank you.